Yes, sir. Good morning.
Good morning, Judge Ireland. May it please the Court, I'm Attorney Timothy Burke. I'm here representing the Commission Officers Association. This is an appeal, if I may, from the allowance of a motion to dismiss on a declaratory judgment and injunction action that was sought to prevent the imposition of the furloughs that were being imposed upon members of the State Police Commission officers. And in 2009 and 2010, because of the fiscal crisis, the governor decided that he would require the managerial employees in the executive branch to be placed on furlough. And they did this through a memorandum that was issued through the Human Resource Department, and that was acted upon by the State Police Department. Now, the Commission Officers Association is not a collective bargaining association. They don't have any rights under 150E. But they are an association. They number approximately 250 and in their total.
It boils down to your position is that they are not managers.
Correct, Judge. And if you look at 150E, the very framework of that statute clearly defines, if I just may read it to the court, I'm sure you're familiar with it, but it says that employees, mandatory language, employees shall be designated as managerial employees only if they A, participate to a substantial degree in formulating or determining policy, or B, assist to a substantial degree in the preparation for or the conduct of collective bargaining on behalf of the public employer, or C, have a substantial responsibility involving the exercise of independent judgment or an appellate responsibility not initially in effect in the administration of a collective bargaining agreement or in personnel administration.
Are you relying on 150E as a source of a remedy?
I'm relying upon it because it is a statute that designates.
But is there a are you contending that there has been a violation of Chapter 150E that
Yes.
itself provides a remedy?
I don't believe the statute in and of itself provides a remedy. But
so where does the remedy come from?
The remedy comes from 231A2, which says it gives the authority for a court to evaluate the rights and the practices and the policies that are being enacted by an agency that are in violation of the law. And what it is, Your Honor, is that they have, even though it doesn't say you have this remedy, it becomes the statute becomes illusory in terms of its effect if it has no right of being enforced.
But your clients don't have any rights under 150E, do they?
They do not. They're not a collective bargaining association. But as the
and
court,
150E expressly excludes them, doesn't it?
It does exclude them, and I attempted to have them added to as a collective bargaining unit. But when you say that it has no rights under the statute, it's the declaratory judgment, as I understand it, allows the court to make the determination if the agency is acting pursuant to that statute and applies it in a wrongful way. And that's what was happened here.
Why do you say that the agency is acting pursuant to 150E?
Because what they have done is they have they're in violation of what the definition is of a managerial employee. There's a specific type of employee, and it's managerial responsibilities. And what they have done is improperly used that term. What they're doing is putting on managerial employees a specific.
You wouldn't disagree, would you, that under, is it 29C? I mean, Section 9C, right?
The governor has the authority
Yes.
to furlough.
Right. So if the governor said, let's say he said, he did this by agency, every executive agency, and he said, with respect to the state police, anybody below the rank of lieutenant colonel or something is going to have to take a furlough. Any problem with that?
Well, I think on a couple levels, that's not what happened here, is that they defined those who were being furloughed as only managerial employees.
I understand that, but I'm just trying to see what the scope of the governor's authority is.
Well, then they run afoul. If they do that, then there's the other issue of statutory violation of Chapter 22C, Section 28A, which guarantees, which also uses mandatory language. It says that individuals who have reached the level of the promotional status of lieutenant are entitled to have maintained this 15.5% differential between their employment salary and that of the highest ranking sergeant. So if you're doing that across the board, you'd have to go down below to the ranks of lieutenant to the actual ranks of sergeant, because they're dependent, the salaries of the state police lieutenants.
The salary is the same. The salary is set. It's just that they have to take these furlough days.
Well, they're being forced to take the furlough days, but it's based upon their interpretation of the statute. And it's a term of art. A managerial employee is only those individuals who fit that criteria. And none of the lieutenants or captains, and there's no dispute about this, none of them fit in that category. They have none of those responsibility. So by the terms of their request in the furlough, they've defined who it is that should be furloughed. They've referred to them as managerial employees.
If the
Not as to
governor-
all the, I'm sorry.
Go ahead, I'm sorry.
Not as to everybody who is below the rank of lieutenant colonel. They have chosen the words managerial employees, and by definition, it's a term of art, and it's defined by this statute.
If the governor had said all state employees shall take a furlough of 5 days,
Absolutely.
would you have a problem?
I wouldn't have a problem with that at all, because he has the authority to do that. But if you're doing it, because then you, across the board, if you have all the state police officers who are being required to take the furlough, there's no impact on that 15.5% differential.
But you
Everybody's-
do have contract issues then, because you have people that are covered by collective bargaining.
Yes, but that's exactly what happens here, is you have officers who are not managers, who are not managerial employees, who don't fit either the HR memorandum or the statutory definition, who have no rights under collective bargaining. They have no administrative remedies. They can't do anything to petition. So they're left with no remedy because they don't fit this criteria.
But don't captains and lieutenants often, well, especially captains, but don't lieutenants also run the shifts at barracks at
But if you look-
various shifts?
Certainly,
Aren't they managing the barracks across the state?
I'm sorry. There's a difference, though, between supervisory responsibility and the specific criteria that are used to define managerial employees. Managerial employees, and if you understand this, the structure of the state police, the only people who fit that category, that definition under 150E, are majors. Majors are different from lieutenants and captains. Lieutenants and captains have to take a promotional exam. And as a result of that, they have civil service rights. They can only be removed for just cause. Majors who have these responsibilities and who also have to file with the State Ethics Commission what their sources of outside income are, the only group that does, is because it reflects their responsibility because they have policy-making authority within the department. So the majors who are managers, managerial employees, and this is historically what they're the ones that sit in the contract negotiations with the sergeants and troopers. They're the ones who make policy. They're the ones who have fiscal responsibility. They're not in charge of the day-to-day operation of a barracks who has some supervisory responsibility. But it's the Commonwealth is the one who set out and defined what the criteria are going to be for a person who's going to be placed on furlough. The state police lieutenants and captains have no remedy. They have no ability to do this other than but through a complaint for injunctive relief based upon the misapplication in the wrongful application of them to those three criteria. And what happens is a result, because you're a major, you're an employee at will. You don't have civil service rights. You can be terminated at will for any reason or no reason whatsoever by the colonel. And there's case law that this court has decided regarding what the rights of a major are under the colonel's authority to have them removed. And that's what distinguishes them as managerial employees versus lieutenants and captains who have civil service rights. They have to take a promotional exam to get to that point. And when they do get to that point, Chapter 28A gives them the guarantee of a salary differential that is there from a sergeant throughout the course of their career. And that's the other area of violation here, is that by the imposition of this 14-day forced furlough program, each one of these officers has incurred a loss of between $6,500 and $7,500, almost $8,000, depending upon what their rank is, lieutenant or captain, as a result of the imposition of this. And they're in legal limbo. They don't have any kind of collective bargaining rights to negotiate or to assert in some administrative remedy. They have no other means other than have a court evaluate through the DEC action.
Can I ask you, regarding the furlough process itself, this wasn't the first time that state police have been furloughed, right?
Second time, Your Honor.
Well, how about the first time around?
The same thing.
Same argument?
I can't say with specificity that my memory is that the same order was issued by HRD in 09 as it was in 010, or in 10.
It was fewer days.
I'm sorry?
Five
Fewer
is
days,
a-
5
five
days
is-
and 9 days. So it's the combination of those 14 days. But it's the same definitional terms that are used. You
So
know,
are you suggesting the HRD memo was somehow the definitive piece, and if a person within an agency didn't fit precisely within there was no discretion to designate that person a management?
I think what happened, Your Honor, is that the HRD took from the 150E a generalized,
It's a little different than 150.
but it's a little bit, yes, but it's still, either way, whether you apply their definition as they put in their memorandum or 150E, neither of the criteria fit lieutenants and captains.
What if they'd said, instead of using the word managerial, they just said the memo said the furlough is going to apply to all non-union executive agency employees?
Well, if they said that, then I'd be in a different position to argue the case.
Would you have an argument?
I think I always have an argument, Your Honor, but
I'm sure you do.
whether you're going to agree with it or not is something else, and that's my business.
Certainly your 28A argument wouldn't go away, would it?
No, it would not. But just to get back to what you said, when you think about whether or not they could just do this unilaterally, perhaps they could. I mean, I haven't explored that and to see what other creative arguments I can make, but I can tell you this, that what they've done here is wrong, and it's left them without a remedy. They're clearly, by any definition, or by their conduct, or by the historical significance of the state police and how their rank structure is, they don't perform these functions. And they should not have been categorized and put into this category. And as the Parker case, which is cited by the AG's office, there may not be a specific remedy that's always available, but the law has no meaning then, and 150E has no meaning if it's not given some force and effect through the vehicle.
But that definitional in 150E is for the purposes of that chapter, which is a collective bargaining agreement chapter. It's not for all purposes. It's just like a major policymaker is for purposes of the financial disclosure law, not for all purposes.
But it's mandatory language, and it says it shall not be considered to be a managerial employee unless they meet those criteria.
Doesn't it say
Purposes of
as
that
used
chapter.
in this chapter?
As used in this chapter.
I understand that, but it still is there that use of the definition that applies here. They're seeking to place managerial employees. You have to have a definition. What constitutes a managerial employee? Then they can just go through all the ranks and say, up to the rank of sergeant, because you have some supervisory authority, we're considering you to be a managerial employee.
I think they could have, but the point is that there are other issues with respect to that, collective bargaining agreement issues.
Take 150E out. Use the criteria that they set forth in their memorandum. None of those criteria are factually fit this particular set of lieutenants and captains. It doesn't apply to them either. So whether you apply 150E
I'm
or
trying to think, directing line organizational functions, captains don't do any of that? They don't direct line organizational functions like running?
well, I'm not sure what directing line organizational functions are.
Yeah,
but
well, that's left to I suppose, the agency.
But
has
isn't that a
to
question of fact then? Isn't that something that should have been, left for the purpose of, rather than just saying,
That suggests you have some rights that grow out of this HRD memorandum.
okay, well, I see my time's running out, but it doesn't elapse, it doesn't eliminate the other claim under Chapter 22C.
Yeah, if I could turn briefly to 28A, I didn't see it in your complaint.
There's no specific reference to it as there's no specific remedy authorized under that either. But the state police were clearly put on notice of that.
How? I mean, I gather it's not in your complaint, and I gather it was not raised in the motion to dismiss. So how was the motion judge supposed to know of your argument?
It was raised in the motion to dismiss. We did argue that in the motion to dismiss. It was briefed, and we asked the court to take judicial notice of the existence of that statute as it impacted the affected officers here. So for those reasons, there was nevertheless a statutory basis that gave them the right to have this issue contested as to whether or not that 15.5% differential should have been maintained. And as a result of this furlough, but for the furlough plan, but for them being treated and categorized wrongfully as managerial employees, that would not have applied. And I suggest to you, too, that if you look at the number of majors within the state police, this memorandum, I suggest, was only intended for the higher level ranking employees, management employees across the board. It wasn't intended because managerial employees, there's only 14 of them in the state police. There's only 14 majors. And it's a very small number, and the same thing across the board for other offices, Executive Office of Public Safety, some of the other executive branches of government.
Mr. Burke, your time is up.
I'm sorry. Thank you very much.
Morning, Your Honor. Daniel Hammond, Assistant Attorney General for the appellees in this case. I'd actually like to start by addressing the 28C claim and then work back to the 150E question, if I may. Judge Gantz asked how that...
Do you mean 28A?
28A, I'm sorry, yes. Thank you. Judge Gantz asked how that statute came into the case, and I'd like to walk the court through that. It was raised in the plaintiff's opposition to the defendant's second motion to dismiss. The second motion to dismiss came up after they had sought and received leave to amend their complaint to add the Wage Act claim. And the Wage Act claim stood for the proposition, or argued that the furlough violated the Wage Act by depriving the plaintiffs of wages earned. And obviously that was a disputed issue. The defendants raised in their complaint that wages earned under the case law referred only retrospectively to work that was performed and for which compensation was due, and that, if anything, in this case, the Wage Act claimed damages were prospective. It was for days not yet worked or that would have been worked but for the furlough. Now, one of the exceptions to the wages earned requirement under the Wage Act is where an employee has a vested right under a contract to wages not yet earned. An example would be vacation pay or something like that, that the employer has somehow frustrated their ability to collect. And I believe what the plaintiffs were suggesting was that Section 28A, because it had these kind of lockstep gradations between ranks, constituted a vested expectation that they would receive those wages. And the response to that, which the Superior Court adopted as well, is that Section 28A speaks to base salary or to salary, not to take-home pay, and that what a furlough does is to reduce the take-home pay. It does not reduce the salary.
Mr. Hammond, I'm sorry, were you finished with that?
I am, Your Honor. Thank you.
Is it your basic position that nobody, let's just assume that the HRD memorandum said everybody, as it says, managerial, and the state police adopted an interpretation of that, because then they implement that, right?
Yes, they do.
And they say, okay, we interpret that to mean people with brown hair have to take furloughs and nobody else. Is there no way to challenge what the state police do in implementing that HRD memorandum?
Well, certainly with an extreme example like that, I'm sure
Oh, no,
that there
but what
was-
would be the, where would you find the cause of action? Because your point is it's
Right.
not under 231A.
Correct.
It's not under 150E for these people. And I'm assuming non-union employees now.
Oh, right, okay. You anticipated my response. You know, I think in an extreme example like your hypothetical, there might be some discrimination law that would come into effect. If they were union employees, there would be some collective bargaining remedy.
But if, I mean, they have total discretion to do whatever they want as long as they don't bump up against the discrimination law.
I think that's correct. I think that is correct.
There's no remedy at all.
Well, as this court has observed in INDEC and other places, there's no equity jurisdiction in the courts to right all or restrain the government from wrongful acts. The cause of action has to be grounded in a statute. And obviously the Superior Court was opining only about the causes of action put forth by these plaintiffs.
No, I understand that. I'm just trying to see what the limits are here, and there aren't any, is what you're saying.
But for the caveats I laid out before, no. I mean, I think this is 9C is a discretionary function in the governor. The memo by HRD was meant as guidance for implementation purposes. It does not in itself create any cause of action. I think the Lafredo case speaks to at least a reluctance on the part of the courts to go looking for implied causes of action, even in regulations, let alone executive pronouncements like the HRD memo. And the governor's action under 29C specifically delegated the discretion to the agencies to determine where that fault line
When the
was.
agency decided to use the terminology that it used, didn't that have consequences?
Well, again, I would go back to the extent that managerial employee is a term of art, it's defined in 150E only as used in this statute. The very first sentence of 150E, Section 1, cabins it off immediately, that only for collective bargaining purposes is this a defined term. And it's a defined term precisely to draw the fault line, among other things, between employees who can
So
and
if we
cannot
don't look to
collectively bargain.
150, where do we look to know what is meant by managerial?
Well, the HRD memo attempted to set forth some general parameters so that, and obviously it's speaking not just to the state police in this situation, but to agencies across the board within the executive department to identify where it's not obvious what kinds of functions a managerial employee versus a non-managerial employee would have.
And do you take the position that it did include the lieutenants and the captains?
I would take the position that it's a rational inference for the state police to have drawn. The reason for delegating the authority to the individual agencies was that they better know the functions of each job slot within their sphere, and that if the state police determined that anybody above the rank of lieutenant or lieutenant and up exercised some managerial functions as defined in the HRD memo, I think that that should be deferred to.
But you would also take the position that it doesn't, I mean, it could be rational or irrational. It doesn't matter. You still don't have a cause of action, as long as you don't hit the union problem or a discrimination problem.
I think that's correct. I think those are the only contours, because this is a 9C vests that discretion in the governor.
It would be totally irrational.
That would be bad policy. I don't believe it would create a cause of action.
So if for 5 or 6 consecutive years, the governor, after having received something from the Secretary of A&F, the governor established a furlough that would be 30 days, and he did this for 5 or 6 years. That would be even that wouldn't be irrational.
It wouldn't be irrational, no. It wouldn't create a legal cause of action, no. It would obviously
But
create...
at what point would something like that become irrational? I mean, at what point could the governor say, for 10 years I'm going to reduce, I'm going to create a furlough system where people will be out of work, notwithstanding their salaries, they'll be out of work for 6 months a year. Is that irrational? I'm going to reduce the state workforce by 50%,
Well,
essentially.
I think at some point you bump up against statutes like that one cited by the plaintiffs, 28A, which talks about gradations between salaries. At some point you're actually affecting salaries, in some cases salaries that are set by statute. And that were the governor to do that, at some point it becomes no longer an annual furlough reduction. It becomes a reduction in salary and could presumably be challenged that way, whether grieved by union employees or brought as a cause of action by non-union employees.
When does a furlough get long enough that you say it affects base salary? I thought your argument was that it never affects base salary.
Well, I think it would be a de facto argument at that point. Justice Spina's hypothetical was that it became essentially a permanent feature of the employment agreement, such that, again, I think that's an extreme. I know you're looking for what's the rule here, and I'm not sure I'm in a position to tell you. But I think the argument in that case would be that it was a de facto salary reduction, whereas a transactional furlough, as we have seen on this record, 2 years, one longer than the other, does not rise to that level.
Would you dispute that, say, $7,000 reduction is significant? According to him?
No, I certainly would not, nor do I mean to downplay any harm suffered by the plaintiffs here. My only argument is that the legislature has not created a cause of action under which they can challenge it.
Anything further?
No, if the court has nothing further, I'll rest on my brief.
Thank you.
Thank you.
Thank you, sir.